it would be, I think, an honor for all of us if Bonnie Gunzenhauser, the Dean of Roosevelt, came up and provided a little welcome to you all.
Just tripped off your tongue. That was good. Very good. Yeah, hi, I'm Bonnie Gunzenhauser. I'm Dean of the college here, and I just want to welcome you. How many of you have been to Roosevelt before? All right, a lot of you, but not all of you. First-timers, welcome. We're happy to have you here. Roosevelt's a university with a really strong social justice mission and a really strong commitment to community engagement. And one of the ways we live our mission of community engagement is through advisory boards where we bring friends and alums back to connect with the university. And one of your members, Ed Mogul, is on our college advisory board, and he was brought onto our advisory board by Joe Loundy, who is the chair of the board and also the founding sponsor of the Joseph Loundy Human Rights Project, which is one of the ways we live our social justice mission. So this event is really a perfect fit for something for us to host at Roosevelt. We're really pleased to have the Illinois Academy of Criminology here, and I'm glad that you all could turn out to make it. And since you came to hear them and not me, I will welcome you. Happy to have you here. Thanks a lot.
The dean gave a really good introduction to who we are, why we're here. What I'd like to say before turning the mic over to our speakers, who are the people you really came to hear, is that this conversation today is about shrinking the justice system, closing the front door, strategies at the very front end of the justice system to reduce the number of folks who become engaged in the system. We have learned a lot about what the system can and cannot do, and what it should do. And these folks will talk to you about what we as practitioners and policymakers are thinking with regard to changes and reforms that will make a huge difference in the number of people who come in contact with the system and reduce that number to hopefully levels that we have not seen in 30, 40, 50 years. They're friends and colleagues of mine. I have a great deal of respect for each of them. Each is very well known. Hopefully you had a chance to look them up, look up their biographies, et cetera. Jack Charlier is the executive director of the Center for Health and Justice at TASC, and he will tell you a little bit more about himself and his work. Sharlyn Grace is with the Chicago Community Bond Fund, and they have done some amazing work with regard to eliminating cash bail and getting people out of jail. And Ben Ruddell with the ACLU is going to talk about major policy change that we can do to affect and reduce the number of people who come in contact with the justice system. After that, we'll have a couple of respondents talk with you all, and then we'll have time for Q&A. I want to remind you that we're being taped, filmed, mic'd, and so this will be then available to folks to stream or to watch at another point in time as well. So it's not just you all, but it's going to be a much greater universe of folks impacted. So when you just wanted you to remember that so you all know. Jack, I think we're going to start with you.
My name is Jack Charlier. As Pam said, I'm the Executive Director of TASC's Center for Health and Justice. Deflection, presentation. Who has heard of the word deflection? Anybody heard of it within the justice context? Well, that's pretty cool because we made up the word like 3 years ago, so that's pretty good. That's excellent. I will go through the presentation. A few things about me if you've not seen me present. Number one, I don't care about getting through all the slides. You can read those later. They're better than NyQuil and much cheaper, so if you need to sleep, you can have a copy of these. Two, I don't read slides. That's your job. I need you to do that. I try to say something witty or funny about the slide, or at least not look stupid, which is always helpful. And then finally, I do want you to take something away from the presentation that's usable to you, whether you're in research or you're a practitioner or a student or a neighbor or a citizen or an advocate, whatever it is, because I cannot give you the next 15 minutes back. So hopefully you'll walk away with something useful, and if not, I owe you a Diet Coke at the door if you can catch me before I leave for the airplane. All right, let's go in and get started. So a lot of you raised your hands. Deflection, just quickly, is a newly emerging field in the United States. We rank it at about 7 years old, no more than that. The concepts, like many things that emerge out of any arena and any field, go back quite a ways, right? This idea, which we'll talk about, of what deflection is, which is using community-based behavioral health at the stage of law enforcement, goes back many, many decades. And again, we'll look a little bit at that. But now it is a formalized field. It is a formalized field that is coming into being. And if any of you are super really interested in this, the second annual, that's how young the field is, the second annual conference is coming up in November in 2019. If you look at Illinois International Association of Chiefs of Police, who I work closely with, their conferences are, 30 plus years on, 15,000 people. National Association of Drug Court Professionals, they're 25 years on, 5,000 people at their conference. This is the early start of a field. So if you want to get into something new and exciting in the realm of law enforcement and behavioral health, deflection is it. It is not a silver bullet for the criminal justice system or for police community relations or for race relations or for shrinking on its own the entirety of the justice system. It is, however, as you will see, a newly emerging practice that is being adopted rapidly in police departments across the United States, and we'll talk about why that is. We like to say that deflection is the handle on the front door. The front door of what? This is audience participation time. The front door of the justice system. Exactly, right? And so when you look at the diagram here, that is the justice system. Doesn't that look like the justice system? Yeah, there you go. Okay, good. And what we like to say in deflection is that if we do what you see just popped up in yellow at the point there, right, that oval that you see popped up, and do that we can do this. We can do what's in green, right? And so this is the front end. So when I talk to my colleagues who I love and respect dearly at bail bond reform, that's cool, but those people are in the justice system. When I talk to my friends who are prosecutors, love them dearly, but those people are in the system. When I talk to my friends who are sheriffs, who run jails, love them dearly, they're in the system. You get the idea. Deflection is the newly emerging field that deals with people who have not yet entered the justice system. And this is going to freak you out, they're not going to enter the justice system under deflection. It is not prosecutorial diversion. It is not bail bond. It is not see a magistrate. It is not stick kind of being waved over you while you go do something. It is, and you'll understand this, I'm going to say the circular definition, deflection is deflection occurring in that space that you see right there that just came up. I hope this is the pointer. If not, I'm going to turn off the projector. Okay, very good. Right here. So you notice we're at the justice community intersect. We're not farther along. Does that make sense? And of course, the justice system also ends with community. So in a way, and you'll see this when I show you the visual that defines deflection in the United States, the green at the beginning of the justice system will touch the green at the end when I show you that visual. Okay, by the way, I know Pam said we have questions. We're holding all questions till the end. Okay, all right, cool, good. All right, so let's keep going here then. Let's see, did I start? Yeah, cut the clicker off? No, good, okay. All right, now it's a rapidly growing field. This is super important. Like I said, I don't read slides. This is just to show you from the top date, and I'll just go through them quickly. You're not going to be able to read them all. That top date is 2019, which of course is, what year is that? That's, no, it's right now. So watch as I go through the slides, right? This will be like a great history class. You could take it for a semester and you'd all get A's. And this is the end of known history coming up in one more slide. Okay, so you can see it goes from 2019 and I'm going to show you one more slide back to 2011. I do want to mark this because it's very cool for TASC. In 2014, we actually are the ones who coined this term. My colleague and I, who used to work with TASC, Maureen, we were grounded at Reagan National Airport because we spent a lot of time in D.C. We had a 4-hour flight delay, which is very common. And we said, we've got to think of a different word for diversion about this new thing we're seeing, and that's where deflection came from. So. But that's it. So if you were taking a class on history of deflection, you'd have 4 slides, you'd have a whole semester to do it, and you'd all get A's. This is how far back it goes, okay? Now, we do know that informally the idea of deflection, which I still haven't defined yet, you've seen a visual of it, informally has been going on for a long, long time, right? We know that. A police sergeant on 3rd shift, she has told her officers, when you get someone and you arrest them and they look like they need to be into drug treatment, here's what I want you to do with them. Take them here. Or a sergeant has said to his staff, hey, look, when we're out on patrol, you get anybody who's got a mental illness, give me a call, I'll come over. This is my background before I became a police officer. Deflection and the idea has been going on for a long, long time. Remember, we're talking about the development of a field of practice that is a formalized set of legislation, policy, training, and practice, okay? All right, so what do we call deflection? Any of these terms that you see up here are good. I use the one in the upper left, which is deflection in red. The federal government, who we spend a lot of time with, is using the one on the bottom right, which is first responder diversion. The reason they say first responder, anybody give an idea of why they may say first responder? Now, you thought you were just going to be able to like listen for like 15 minutes. You can't do that with me. The feds look at it also as fire and EMS. And in fact, in the evolution of the development of deflection in the United States, fire and EMS have in some ways long been doing this, right? But fire now is officially part of the movement, and there are fire stations instead of police stations that are doing deflection. We'll talk a little bit more about that. Any of these terms are good. It doesn't matter as long as you're looking at the bottom of the slide, which says that police traditionally have had two options formally, number one and number two. Makes sense, right? With deflection, they are then able, along with community partners and with community, to be trained on the third option, which is to deflect. Again, I still haven't defined it. When we get to it, you'll be like, yes, that's exactly what I was thinking deflection is, right? That is what they're being trained on and giving a formal third option. Now, I know we've got Roger here who had a great career in CPD. I'm not going to put words in his mouth, but we know that officers have long done this informally. Again, this is about the practice of deflection by policy, by training, and by partnerships with community-based treatment. So it is about a third way for police. One quick note on this, when I speak to lay audiences, as in non-criminal justice folks who have involvement in the justice system or work with it, I say, what can police do? Almost everybody raises their hand and say they can arrest people. Rarely does anybody actually get the second one, where you can take no action. You can drive away. I think Roger's at 19 Paul for CPD. They 19 Pauled, which is the radio code for we're moving on, we're done here. But they do get, oddly, that police could do something else, which is ironic because it's only now emerging as a practice. In other words, we've thought about this idea that police could be doing something else formally, but in practice, it's really the first two things that has been the mainstay of their work. Okay? All right, deflection. This now then is deflection. I said I hadn't defined it yet. This is deflection, and you can take a look at it. And as I said, I don't read slides. I want to just highlight the part, though, without having entered it. So if you are doing prosecutorial, jail, court diversion, parole, probation, you need to get out of your mind, which is not easy to do, that there's going to be justice involvement. In about 90% of deflection in the United States, there is no justice involvement at all. There is no arrest. In the legal sense, there is no arrest. Somebody might be put into a squad car, they might be taken to a station or a facility, not a jail, but that's just for the purpose of deflecting them. There is no arrest, all right? They do not go into the justice system. How does this differ? How many of you know the word diversion within the justice context? Okay, almost every hand is up. You all know diversion. That's the right-hand side. And when it comes to diversion, you can see now, compare and contrast, right? Third grade, compare and contrast, left to right, and you can see the main difference that's going on here. Another item is that the justice system really controls diversion. Deflection as practiced might be initiated by a law enforcement, a police department, and a community, but it's often equally controlled by treatment and by the community itself. So if you went to Atlanta and you saw their deflection initiative, that was initiated by a couple neighborhoods and civic leaders in Atlanta. If you go to the west side of Chicago and you'll see the West Side Community Triage and Wellness Center, that was initiated out of the Austin community, but police obviously participated, and you can't do this without them, right? Okay, so when you think about this, again, think about, hey, the idea here is that it's sitting in a community, it's community-based, law enforcement absolutely must participate, fire and EMS can be part of it, should be part of it, and we'll explain why in a second. But what's really going on is the control is sitting with the individual and with the community. That's the ideal of this, all right? Okay, the next slide I'm just going to leave up for about 5 seconds, and all it says is this. There's one type of deflection, and that's on the left, where there are no charges. Remember I said about 90% of deflection, there are no charges. There never were going to be any charges, and there aren't going to be in the future in terms of the incident or whatever it is that brought the officer there. And that's called prevention deflection. It's only important that you remember prevention deflection, no charges. The right-hand side is called intervention deflection. That's where there are charges. Intervention is charges. You said, Jack, you're a liar. You said there are no charges. They're charges, but they're held in abeyance, or a mechanism that is not justice involvement is used to deal with them that includes treatment. So how many of you heard of citation in lieu of arrest? A few hands, okay. So you get the idea. I give a citation in lieu of arrest. The right-hand side is intervention deflection, is citation in lieu of arrest if you add in treatment. Citation in lieu of arrest on its own is not deflection. That's just using one mechanism for another if you were to add in treatment. So prevention deflection, prevention PAD, pre-arrest diversion, is no charges. About 90% of the field is doing that. And then the right-hand side, there are charges, but they're held in abeyance. The person does not enter the justice system. Good? Cool? Okay, that's it. All right, why are we doing deflection? I'm going to just put up a few slides. I'm going to assume that a lot of you know this, so we'll go quicker. Yep, that's fine. This is one slide. What are the two main drivers of justice system involvement? Read the slide. What are they? And? There you go. Okay, all right. That's one of the main drivers, all right? One of the other things that we might look at as a reason or rationale for deflection is this, right? The idea of our rate of incarceration. When I click the thing, is the U.S. bar going to be higher or lower than every other country? Higher. Okay, all right. You guys are good game show contestants. What's the one we have to say higher, higher, and the audience shouts out? Okay, so this might be a avenue for deflection. I want to share this with you. These next two slides, I think, very impactful. We think a lot of the challenges that are going on in some communities with police-community relations, and so we think that that's one of the things that deflection will get at, because if we don't begin with an arrest in the first place, we're going to end up in a very different place than someone who has been involved in the justice system. I think the next speaker is going to come up and talk about bonds. So you see bail bond reform. If you're not in the justice system in the first place, you don't have to do bail bond reform because you're not in the justice system in the first place. And other things that are going on. Okay? Finally, and then I'll show you just a few more slides and I'm going to stop. I really like this one a lot. We work very closely with the International Association of Chiefs of Police, National Sheriff's Association on deflection. Why? Because law enforcement has to be involved in it. This is the state of play, if you will, for the main organization for chiefs of police in the United States, right from their book on how police should deal with vulnerable populations. That's a pretty powerful quote, right? I bet you a lot of people would not know that that's sitting in there. And it's a whole book on dealing with folks who have substance use disorder, mental health issues, not just SMI, but just straight kind of mental health that presents itself, trauma, housing, and services. And it says this. A lot of people would not know that this is kind of where the direction of the movement of policing is going. Okay? All right, let me just show you two more slides and then we're going to stop. First of all, in the United States, there are about this many people encountered every year by law enforcement. Okay, how many people churn through the jails every year? Any idea? So if this is how many encountered, how many churn through the jails every year? Okay, about this many. Okay, and what is the math if you subtract those two out? Well, you guys got to... You knew I was going to ask you, what is the math? The math is 44 million, right? And so what we'd like to say in deflection is that while not everybody who is encountered by police, in fact, the vast majority don't need deflection because they don't have a substance use disorder problem, they don't have a mental health issue, they're not kind of dealing with trauma. However, it does present the earliest line possible, if you think about this, for law enforcement in encountering folks for whom the next time they see Jack, one of three things is possible if we don't have deflection built into our law enforcement. I'm dead because I'm doing something that causes me to die. 2, I now have to be arrested. There is no deflection option. They have to arrest me. Or 3, and I hear that, Pam. I'm going to show one more slide. I hear it. It's fine. Yeah. Yeah, okay, well, that's right. I did. You're still a great boss, though, Pam. But 3rd, that I just watch your life as an officer spiral more and more out of control, right? Spiral more and more out of control. 81% of law enforcement encounters in the United States are either entirely social service calls when we do a forensic analysis of them or partly social service calls. In other words, law enforcement is running into folks all the time for whom a connection to community-based treatment, housing, and services would be massively beneficial without use of the justice system. And the officers know it. They are smart people. They are on the street seeing these folks over and over and over, and we have not given them the tools to do their job. And as a result, we ask them to pick up all sorts of things for which they're neither equipped or trained, but we want to hold them accountable. Deflection offers something to law enforcement too, which is an avenue and a path for you to do the job you were hired to by sharing with community-based behavioral health, housing, and services the work they were hired and are paid to do. Okay, last slide I'll show you then. is this, and again, the rest of the presentation just goes into detail on this. This is what the deflection field looks like in the United States. Remember I told you it'd be green to green. What do you notice about it? Is the justice system on here, other than police and law enforcement in terms of the very front end? It's primarily not, right? Do you see jails on here? Prosecutors, probation, parole, courts, prisons? No. You see community. Everything within deflection occurs in community. And what we like to say is this: in deflection, while staying in green, we want to get you from blue to orange through these 5 ways, from blue to orange. How do we get you from here to here while always staying within community? And the way we do it is one of these 5, and Pam, I'm going to indulge you for 90 more seconds, and I promise you that's it. These are the 5 ways that you can do deflection. Again, if you want the PowerPoint, you can have it. The way to think about it, though, is this is a dam, right? This is the water, and we want to get the water to the other side so this can grow and be healthy. Each one of these are avenues by which, if we open up what's called self-referral deflection, we allow police stations to be places where people can walk in, self-refer themselves and say, I need treatment. That opens up this part of the dam, and the blue can flow through here. Make sense? All right, naloxone plus, where we work in areas of the country that are hit very hard by the opiate epidemic. Numbers are like, we don't see anything like this in Chicago. I mean, the true kind of where things are happening, talking a couple hundred overdoses a weekend on a regular basis. By opening up the naloxone plus, what's called pathway, we open this up. And now we've got the blue flowing through here and through here. And the idea is we want all the pathways open so that we can have a maximum number of opportunities for citizens and residents of communities to get access to treatment, housing, and services when they encounter law enforcement in non-arrest situations. Arrest situations are handled by the justice system through diversion. This is deflection. New practice emerging in the United States. I will stop there, and again, if you want the slides, just come and see me, or they might have them. But that's deflection, and very much appreciate your time. And Pam, thanks for letting me go over just a little bit.
Hi, everyone. My name's Sharlyn Grace. I work with Chicago Community Bond Fund, and as Jack previewed, I am going to talk about bail and bond reform, and you might already know that in Illinois, those terms are used interchangeably, bail, bond. In other states, they may mean specific things. So, and specifically, I was asked to talk about what we're doing as we move away from the use of money bail. So what we're doing instead of requiring someone who is accused and presumed innocent to put up a certain amount of money before being released, or more realistically, asking someone who cares about them to put up that amount of money, because it's a reality that almost no one is paying their own money bonds in Illinois or anywhere else. It's primarily people who care about them, and it's often mothers, girlfriends, and other women. So the first thing that I wanted to emphasize for all of us and get clear on is that secured money bail doesn't work. Requiring people to put up money with the idea that it will increase the chances they come back to court in the future is not effective. There is no reputable study, not funded by the bail bonds industry, that has found that it's effective. And there are new studies now that are finding it may actually increase recidivism rates when we require people to pay money. So not even talking about when people can't afford to pay their bonds and they end up in jail, which we know increases recidivism, but even when someone in their life puts up that money for them and they secure their release pre-trial, the hardship of coming up with that money actually increases the chances that that person will be re-involved in the justice system in the future. So what is money bond doing? It is driving pretrial incarceration, driving pretrial detention. So in the last 30 years, similar to prison populations, the number of people in local jails has increased dramatically. And 99% of that growth has been in people who are pretrial and are presumed innocent, and not people who are serving sentences of under a year in local jails. And we also know, I think many of the people in this room, the consequences of what that pretrial incarceration does. It increases the likelihood that someone will be convicted. It increases the lengths of sentences for people who are convicted. It increases recidivism. So the destabilizing impact that it has on people's lives when they lose a job if they had a job, lose stable housing if they had it, lose connection or strain any positive social relationships or supports that they have. If they're connected to any kind of medical or mental health treatment in the community, that's going to be disrupted most of the time when they're jailed. So we see that that causes people to be more likely to be involved in the future. And then I think it's also important to say that putting people in jail actually kills them. Jails are very dangerous places, particularly for people with medical needs related to substance use disorders or other medical needs, for people who have severe mental illness. And the most dangerous time for people to be in jail is that first week, and especially even those first couple of days. So the very high rates of mortality that we see in jails, it happens immediately. And I think we need to be clear about what the consequences are when we put people in jail, including if it's only for a few days. So, and it also serves, I will say that money bail and pretrial incarceration also serve a different sort of function within the criminal justice system. So we know that part of the reason conviction rates are higher for people who are in jail as opposed to people who are free, and part of the reason the sentences are longer, is because people feel more coerced into taking plea deals. It is easier to resolve cases when someone is in custody than when they are free. And people who are in custody are more likely to receive a sentence that's custodial, that includes further incarceration. So it serves a useful function sort of in case processing, if you think about just the pure efficiency of moving people through this system that has grown so much over the past few decades. And that is a benefit in the eyes of some people in the system. And others, of course, we see it as a great source of unfairness and a source of coercion that shouldn't be there. But I think it's important to recognize that for some people within the system, it is seen as a benefit. So what should we be doing instead? The simplest thing that we can do that's been proven over and over again to work is just send people text message or phone call reminders. It's very simple. Our dentist's offices do it. The people who cut my hair do it, but we don't put any of that level of support into the justice system for people who, in many cases, have very chaotic lives, have a lot of other struggles, have a lot of other needs that are going unmet, and could use that level of support and will come back to court at much higher rates if they are just given phone call and text message reminders. It's also very cheap, certainly much cheaper than jailing many people. And we'd also like to see many other kinds of supportive services. So one of the most obvious ones is transportation assistance. So a lot of times in places with public transit, that could mean bus cards. In Minneapolis, the Public Defender's Office is actually doing a pilot program with funding from MacArthur Foundation that's providing Lyft and Uber rides to the people who are most at risk of missing their court dates, who are mostly people accused of misdemeanors there in Minneapolis. So really helping people meet the needs that keep them from coming back to court. We know why people don't come back to court in many cases. We're not talking about people, overwhelmingly, people who miss court are not people who are fleeing prosecution. They're not even people who are probably leaving their neighborhood regularly. A lot of times it is about not getting to court or not having some need met. And so if we can step in, we can provide transportation, we can provide childcare at the courthouses, we can provide those reminders, then we're going to dramatically increase the rates at which people come back to court. And then another proposal for what we replace money bail with is even simpler and cheaper. It's nothing. Many people should just be released with personal recognizance bonds. And what we know, in Illinois, that's an I bond. And what we know is that the vast majority of people are going to come back to court anyway, that it's not actually about grandma having put up money or mom having put up money. And it's also very important to remember that many other times when we think about pretrial services, what actually happens is the imposition of conditions that can be punitive, they can amount to restrictions on liberty. So under the banner of pretrial services, we have seen the imposition of house arrest with electronic monitoring. We've seen check-ins with probation officers. So things that are not necessarily proven to increase court appearance, and in some cases are proven to increase failure rates because they've increased the conditions that people have to abide by. And we really have to challenge ourselves in this context to remember that people are pre-trial and that the presumption of innocence means not just that people should not be subjected to incarceration in the jail, but that we need to be extremely cognizant of any restrictions on liberty that are imposed, and whether or not they are voluntary and supportive, or whether or not they are going to be experienced as a loss of liberty to someone who's pre-trial, and also whether or not they're going to ultimately end up resulting in someone's incarceration, even someone who's released. So this is something that we've seen happen a number of times with folks that the bond fund paid bond for. They're given a condition of release to check in with a pretrial services officer. They call, they don't reach someone. Maybe they call several times. Maybe they just call that one time. They don't call back. They show up to their court date. And then at the court date, it's reported that they weren't compliant, that they never made contact with the pretrial services officer. And we have had some people who are taken into custody then, who then lose their liberty because they failed to make that phone contact. But the point of the phone contact was supposed to support them in getting to court. So if we have lost sight of that, such that someone has come back to court, and then in succeeding, they are being locked up because they failed to meet this other condition that was supposed to help them. It's very easy for the court system to take the things that we do in the post-adjudication punishment context, in which someone has been convicted of something, and sort of transfer them to this stage where someone is pre-trial. And we need to be very wary of that when we're developing any conditions or services, and to really try to separate what's a condition and what's a service. So what has reform looked like so far in Cook County? I'm excited that we can now talk about this and use Cook County as an example of what successful reforms look like. Probably a lot of people in the room know that the number of people in Cook County Jail has decreased by nearly 50% since 2013. So it's a huge difference from more than 10,000 people in jail every day to fewer than 6,000 people in jail on any given day right now. And we've basically doubled the number of people who are released on their own recognizance and nearly halved the number of people who are being given money bonds. And what that has looked like is that there has been no significant change in the rates of court appearance, and there's been actually a slight decrease in the number of people who are rearrested for an offense that's considered violent. And it's a very, very slight decrease because almost no one is arrested while out on bond for an offense that's considered violent. So from before reforms went into effect in the fall of 2017, that rearrest rate for a violent offense, and that's not a conviction rate, it's just an arrest rate for something that includes a charge that's violent, was just slightly more than 0.5%, 0.7%. And now post-reform, it's even lower, which is 0.6%. And I think one of the things that I wanted to be sure to talk about in the criminology context is something where I think there's often a conflict between, not to paint with a very broad brush, but criminology or more research-based folks who are providing technical assistance to system actors, folks who are system actors, and community-based advocates for reform, and that's around how we make decisions and what the role of risk assessments are. So first, we know when we're talking about the criminal justice system that everyone is entitled to an individualized hearing. That's what people get in the criminal justice system, and that's what people are supposed to get. And that's especially true when we're talking about something as high stakes as potentially losing your liberty. And we know under the U.S. Constitution and most of the state constitutions, there is a right to pretrial freedom, what we say a right to bail. There's just supposed to be a very high bar before the government can take away your freedom while you're presumed innocent. And that's what we would all want if we were accused. So we have to start out with the baseline understanding that the overwhelming majority of people should be released. And then working from that, there are a lot of advocates that are very excited about the possibilities presented by risk assessment tools, and there are a lot of community groups and also some advocates who are extremely worried about them. And so I just wanted to talk very briefly about why some of that worry is. And a lot of it is about the lack of precision, that most risk assessment tools are looking at whether or not someone will come back to court and whether or not they will be rearrested on a new charge. And the tools that exist, and in part it's because the records that exist are not very good at distinguishing between the things we care about, right? So missing a court date, a failure to appear in one's history or one's future is not the same thing as willfully fleeing prosecution. And as we talked about earlier, most people who are missing court are not fleeing. They're simply missing court, and most of them will be back in court in the future. And it's the same thing with risk of arrest for a new offense while out on bond. So when many of us think about that and we think about what the standard should be before someone loses their liberty, we're thinking about a serious risk, something that involves violence to another person, most likely. The kind of rearrest that we care about and that might risk someone losing their freedom. But what we generate the most data on and what we see the most of is that many times it's people who are arrested on very low-level things who are much more likely to be rearrested in the future. And the tools that we have are going to accurately predict that someone who is experiencing homelessness and substance use, they're addicted to something, and they have been arrested for retail theft. They have been arrested for retail theft before, quite frequently, and the tool is going to say, if we release this person, there's a very high chance that they will be rearrested for another offense, whether that's retail theft again, whether it's possession of a controlled substance, it's trespassing, whatever it is. And the tool is accurate, but the tool is just reflecting the fact that we as a society in large part still criminalize addiction, we criminalize unmet mental health needs. And we really have to wrestle with the relationship of accuracy to fairness and recognize that the tools we have now are not very good at predicting the things we care about. Because I would argue that that person, even though the tool can say this person is very likely to be rearrested in the future, that person still should not lose their liberty and be in jail, especially if it's someone who is struggling with addiction, and putting them in the jail increases their likelihood of overdose in the future. So part of the reason it's so hard for the tools to make accurate predictions is because the things that we care about are very rare. So it can be very hard to build a tool that catches that 0.5% of people who are going to be rearrested on a charge that's considered violent. So in Cook County, we use a risk assessment tool. We use the Arnold Foundation's public safety assessment. And recent data released has allowed us to look at the tool's predictions. And what we've seen is that of people who are indicated by the tool of having a risk of being rearrested on a new violent offense, the rearrest rate was 1%, which means of the people who were flagged as having this risk for a new violent offense, 99% of them succeeded. And the rearrest rate for the people who didn't receive that flag was about 0.5%. So we're looking at a difference of 0.5% in accuracy of prediction. And in focusing our search on that 1% or that 0.5%, we also have inflated in the process, in the eyes of the judges and the decision makers and the public and the media, we have inflated the risk of violence so that we're now screening everyone and looking for this and trying to identify it when it is actually extremely rare. And there are a number of other challenges with risk assessment that I don't want to run out of time to talk about. The most important one for community-based advocates is the racial disparities and the racism that is reflected in existing criminal justice records. So every risk assessment, the most accurate predictor that it's going to look at is someone's past history of involvement in the criminal justice system. And we know that that is going to be reflective of where someone lives, and that because of economic and racial segregation, different communities are policed differently. Different people are going to have different levels of exposure, and that in many ways, a tool that is reliant on that data is going to end up feeding that back, only sort of laundered through what's supposed to be a scientific or an objective predictor, when it may be accurately predicting how we police the neighborhood that someone lives in. So I'm out of time, so if we can talk more about, we are also big supporters of citation in lieu of arrest and deflection and keeping people from entering the criminal justice system in general as part of bail reform. But in terms of actually making the decisions once someone's been prosecuted, really what we're pushing everyone towards is robust, individualized hearings for anyone who's eligible for detention, which shouldn't be everyone.
Good afternoon, everyone. My name is Ben Ruddell. I'm the Director of Criminal Justice Policy at the American Civil Liberties Union of Illinois. Make sure I talk into the mic as I was told to do. I want to thank you all for having me here today. Thank my fellow panelists for their excellent presentations. And so to start out, I just want to talk about a myth that I think, the people in here in this audience are probably aware is a myth. The idea that, the mass incarceration problem we have in this country is due solely or primarily to the incarceration of the so-called low-level drug offenders. Honestly, to unwind our crisis of mass incarceration is going to take a lot more than simply changing those policies. We're going to have to confront issues of violence that really drive the long sentence length that is as much really more of a driver of incarceration than the high number of people that we admit into the system who churn through and generally serve short sentences and are frequent flyers. We need to do both, but I thought that was important because I'm going to be talking much more about the latter than the former, but I think it's important to know that this is one sort of tiny, it truly is a front-end intervention we're talking about. I handed out 2 documents. One of them I'm not going to talk about. It's called Broken. This is our ACLU of Illinois Criminal Justice Policy Guide that talks in general terms, but talks more comprehensively about the many changes we need to make at different points in the system about in order to solve the mass incarceration crisis in this state. And I'm not going to talk about the contents of that document, but I wanted to invite you all to look at it to get some greater context for this problem as our organization sees it. So just a little bit about my work. I lead our criminal justice policy work, and that's primarily in the, not in court, but in the Illinois General Assembly. So drafting legislation, analyzing legislation, testifying in committees in Springfield, that's the type of thing that I do. So front-end interventions. One of the things that our organization has identified as an important front-end intervention is fewer people need to be made felons, given felony records. Some of the offenses that we're charging people with and convicting people of and incarcerating them for are classified as felonies and ought to be classified as misdemeanors or perhaps not as crimes at all. And one thing that a lot of people in Illinois and outside of Illinois agree on is that possessing drugs is one of those things, that we're putting too many people inside the criminal justice system, saddling too many people with felony records because they possess drugs. And so we're using this term that we're trying to find a better term for, defelonization. Nobody likes the word, and we're working on rebranding it, but for the purpose of this presentation, that's what I'm going to be calling it. And basically what we're talking about is currently drug possession, any quantity of any illegal drug in Illinois is always classified as a felony. And that shouldn't be the case. So we're working with coalition partners to pass legislation that would reclassify the penalty for small-scale drug possession from a felony to a misdemeanor. As I mentioned, a lot of you, I think, are knowledgeable, but just to make sure we're all talking the same language, felonies versus misdemeanors. In Illinois, this is different under some states' laws, how they classify these things, but in Illinois, what it really means is a felony is a crime for which a person can go to the Department of Corrections, to the state prison system, although they don't have to, they could get probation. But for a misdemeanor, a person cannot go to the state prison system. They can be incarcerated, but if they are incarcerated, it'll be for no more than a year, and it will be in the county jail. Most of you probably already know that, but I want to make sure. Secondly, what are we talking about when we talk about drug possession? Basically everything besides marijuana. Marijuana is going to be a legal substance on January 1st, and marijuana was the exception to the rule. There were misdemeanors for low-level marijuana possession, but there's no misdemeanor for low-level cocaine possession or fentanyl or methamphetamine or heroin or MDMA or any of the many other drugs that people use. So we talk about simple possession. What are we talking about? Well, in the most common statutes that people get prosecuted under for drug crimes are possession of a controlled substance or possession of methamphetamine, which is classified in its own statute, or possession with intent to deliver, which is lumped in with manufacture, delivery, is exactly the same for the purpose of the penalty. Intent to deliver is a factual question that needs to be proven at trial, but the important thing to know is this initiative, this proposal that I'm talking to you about, deals with only the former and not the latter. So we're talking about the penalties for possessing a controlled substance, possessing methamphetamine, not with the intent to deliver, but just merely possession. So another thing it's important to understand about how we classify drug penalties in Illinois is that quantity is important. We use quantity thresholds. And so for most drugs, most of the big controlled substances like heroin, cocaine, 15 grams is an important threshold because that's where you go from the lowest level felony. As I said, they all start at felonies, but they start at a class 4 felony. Once you get up to 15 grams, you're not just moving up one rung on the ladder, you're moving up 3. So you're into class 1 felony land. Now instead of 1 to 3 years in DOC, you're looking at 4 to 15 potentially. And then once you get up above 100 grams, you climb another rung and another and another. I mean, until you get up into these sentences that are decades long for the large amount possession. And one quirk of our law that's also important to understand is when we talk about the quantity of a drug, we're not talking about the quantity of cocaine, just to use an example, by itself. So on the street, in reality, you buy a bag of cocaine, you're buying a bag of cocaine mixed with other stuff. How much cocaine and how much other stuff may vary, but usually it's not going to be a pure quantity of that controlled substance. But for the purposes of the law, it makes no difference. A gram of cocaine, of a substance that's baking soda with an infinitesimal amount of cocaine, is punished exactly the same way as possessing a gram of pure cocaine. So it's a substance containing cocaine that's the operative question here when we're measuring the quantity. And street dealers often cut substances in order to, with fillers and other drugs, in order to maximize their profit. So that has real implications for how these things are punished. Why should we care? Convicting somebody of a drug possession crime, whether it's a felony as now or a misdemeanor under this proposal, frankly, has consequences, negative consequences in people's lives, for employment, for housing, for education. They experience social stigma, even where the law doesn't prohibit you from holding a job or doing something. You're subject to background checks, and you have employers who say, I don't want to hire somebody who's got a felony, or I don't want to rent to landlords who say, I don't want to rent to somebody who has a felony. One thing that's not on here, but probably should be, is penalty enhancements. If a person gets charged with an offense later on, having a felony on their record could have serious implications for what they'll be charged with and what sentence they might receive in that later charge. So, like I said, misdemeanor convictions have collateral consequences too, but felonies have the most severe collateral consequences. Misdemeanor convictions, unlike felonies, can be sealed. If a person goes to court and goes through the appropriate process, they can petition to have that record sealed, where law enforcement can still look at it, but employers, landlords, etc. cannot. Felonies are not subject to sealing. So unless you're able to, get a pardon, an expungement, or something like that, you're really stuck with this felony for the long term and all the collateral consequences that come with it. So how many people are impacted? Well, from 2016, and this data is from SPAC, who did an analysis, the Sentencing Policy Advisory Council, for those of you unfamiliar with SPAC, who did an analysis of our draft legislation, and they found that for this 3-year period, we had about 20,000 people convicted of felonies for small-scale drug possession, and I'll talk about what that means in a minute. And more than 7,500 of those people went to prison. So not an insignificant number of people we're talking about. And here's the data broken down a little more. There's a copy of this presentation for you all to look at, so I'm not going to dwell on the individual numbers. So who are those people? Demographically, black people, and specifically black men, make up a highly disproportionate percentage of these folks who are going to prison for these low-level drug offenses. As you can see, black convicted persons comprise about 70% of those that are incarcerated for controlled substance possession. And there's another representation that also shows that Cook County is the big, sends far more folks to prison than any place else in the state. Not surprisingly, because of how populous this county is. You see, though, for methamphetamine, it's the opposite. Rural whites make up the people who primarily are going to prison for possessing methamphetamine. Women are a relatively small but a growing percentage of the population at large, and of the approximately 2,500 women currently imprisoned here, about 80% are mothers. Somebody pointed out I should have the figure how many are mothers of minor children, and I don't have it at hand, but it's a high percentage too. And the women versus men, they tend to be in there for lower level offenses. They tend to be in there for drug offenses more commonly than men are. And as far as the counties that send people to prison, you see Cook and other populous urban counties are mostly at the top of the list. You've got the suburban counties. You've got Winnebago, where Rockford is, Peoria County, all making the top of the list. And then when you look at meth, it's completely different. It's all these rural counties. So the good news about Illinois' prison population is it's been moving in the right direction, down. Over the past 20 years, the population has decreased by more than 5,000. And what's interesting is we're sending a lot fewer people to prison for drug offenses broadly, all drug offenses, but about the same percentage of the people who are incarcerated now, now versus 20 years ago, the percentage there of people there for simple possession is about the same. It's at about 5%, so it's a smaller number, but it's the same percentage of the overall total of our prison population, and that's represented here on these pie charts, where you can see, for instance, drug delivery used to be 20% and is down to 9%. Drug possession holding steady at 5%. Just more population numbers. We were nearly at 50,000 in our prison system in 2013, and it's declined substantially. And according to the research done by Dr. David Olson at Loyola, a substantial proportion of that decline is attributable not just to fewer arrests for felony drug law violations, and that's important though. There are fewer people being arrested by the police for these. So something's going on at street level, and I would submit to you, it's not fewer people using drugs. But of the decline, of that substantial decline that's happened since 2013, where we're down about 8,000 in population, it's mostly been attributable to arrests in 3 police districts in Chicago. 14% of that decline can be pinpointed to specific neighborhoods in this city. And as Dr. Olson said, that parallels what happened that brought us to this point in the first place. We were over-policing those neighborhoods and incarcerating far too many people from those neighborhoods. So what are we proposing? What's the plan? So the first thing is we create new quantity thresholds, and this is House Bill 2291 you see up there. We have legislation to do this. And so for every drug, we're looking at carving out new kind of lower quantity thresholds. So for a drug like heroin or fentanyl, it'd be about 3 grams in what we've introduced in the legislature. For cocaine, it'd be 5 grams. But for every drug, we're establishing a new threshold below which simple possession would be classified as a misdemeanor, and above which it would remain a felony. So, like I said, though, we don't really want people who are currently getting felonies to be convicted of misdemeanors. Those have collateral consequences too. System involvement is harmful. Incarceration is harmful. Having a record is harmful. So what we really would like is for people, in an ideal world, we'd like the police to be utilizing deflection like Jack was talking about, and not bringing people in the system at all. But when people are brought into the system and they're charged with a misdemeanor, there ought to be an off-ramp. There ought to be a diversion program. And so we have, and there's nothing, we don't need a new law, frankly, for prosecutors to divert people. But we thought it was important to make explicit that that's what we want to happen, and here's how it ought to happen. And it ought to be a light touch. It shouldn't be, we're going to supervise you for 2 years and give you drug tests and have curfews and check-ins with probation officers, and when you slip up, then you run the risk of going back to prison, because that's what a lot of current diversion programs look like. We are looking to transition how we deal with drugs from the criminal justice system to the healthcare system. And so what we're looking is for people who come into contact with the system to be evaluated for behavioral health needs. If the evaluation suggests they have those needs, to go to a provider and get a treatment plan. And if they do those 2 steps, and to be connected with services that exist in their community-based services. And if they go through those steps, we drop the charges. And because, coerced treatment is being offered in a lot of places as an alternative to incarceration, and that doesn't work either. People come out of jail and they overdose at a high rate. There's a whole lot of things which Sharlyn talked about a little bit. So we're not doing mandatory treatment. We're talking about making voluntary treatment available, identifying what the needs are, and connecting people with those services that meet their needs. Finally, this bill is retroactive, so people who are serving sentences or previously served sentences and carrying records based on the old laws that we're now hopefully going to acknowledge are outmoded, shouldn't be stuck with these records or serving these sentences. And so it would be a mechanism for them to have the record corrected to reflect the current state of the law, or if they're serving a sentence, to be resentenced. What happened last year, so here's some of the organizations that support this. You can see them on your handout. I'm just going to go to the last slide. What happened in the legislature? So this is, we had this bill last year in the legislature. The law enforcement groups, primarily the prosecutors, were opposed and made that known and pushed back. So, when we talked to the prosecutors, they opposed reclassifying any offenses for any drugs, arguing that, people won't voluntarily access treatment. They need to be coerced. They need to be incarcerated. Misdemeanor penalties are not a strong enough stick to coerce them to do that. And so the alternative they offered us is we could build a new prison where people can be treated and then come out if they go through all the steps without a felony record, which just kind of shows what different languages we're speaking here. So I understand my time is up. I look forward to answering questions, but thank you.
Hi, I'm David Ader, president of the Academy, and I was just asked to make a few comments. A lot of this obviously is new to me, but I do have a few thoughts that to share. First of all, in terms of deflection, if the individual is suffering an overdose or some other thing where the only matter that the police are responding to or other emergency services responding to is the person's own ill state of health, addiction, whatever, I don't see any problem with deflection. And frankly, the whole program today has been a very happy one because it shows that, number one, everyone is trying to be humane. In this area, used to be that criminal law was an area where there were a lot of people that really wanted to be tough. And now we're getting a much more humane look at it. So I'm very happy about that. And another aspect I'm happy about is clearly our criminal justice system has some problems. And now we have people, the society is still alive and well, despite what's happening in Washington and elsewhere. There are a lot of citizen groups and others that are trying to remedy, still have the energy and the interest to remedy or try to remedy some of these problems. But what I'm concerned about in terms of deflection is that the individual who actually is carrying either a felony amount or a misdemeanor amount of drugs, that person is more than suffering ill health, where the police are acting in a social service aspect. They are, in fact, until the law is changed, and I'm speaking as a lawyer, until the law is changed, the legislature has said these people are lawbreakers. And therefore, to give the police or to ask the police who are sworn to uphold the law and enforce the law to essentially circumvent the law and to take people who are otherwise in drug possession that would make them criminals and say, well, we're not going to give them to the criminal justice system by diversion or elsewhere where they might be treated more nicely, but at least they're within the criminal justice system. And to avoid the criminal justice system entirely through deflection, I think it is a problem. I think it subverts, in part, the function of the police and asks them to ignore their sworn duty to uphold the law. And there's a second problem, and that is you're not going to reach everyone. And so if some are going to be charged with felonies or with misdemeanors, and others are going to be allowed to circumvent the system, you have, in my opinion, an equal protection problem, a constitutional problem of violating the equal protection of those who were subjected to criminal prosecution when others were allowed to escape it. So I'm concerned about that. I think, however, it's a worthwhile objective and certainly something that should be part of the attempt of the ACLU and others to actually change the criminal law. If you change the criminal law, then of course the law conforms to what you would like the police to do and all, and everyone is on the same page and no one is violating the law or undercutting the law. In terms of what going on in the legislature, I would have a couple of comments. The first is our criminal code dates back to 1961, so it's over half a century old now. And obviously a lot of things have happened in society, new crimes, new technology, and so forth that the criminal code may not even address. But in terms of what it does address, legislators over time have always been willing to raise penalties. If there's a problem, they're the law enforcement mentality, so they increase the penalties. And what used to be a very measured, very well drawn, probably the leading criminal code in the nation in 1961 has now become sort of a hodgepodge, so that if you're dealing with manslaughter or murder or negligent homicide, and I haven't looked at it recently, but I'm assuming that those penalties have creeped closer and closer together. So what's the purpose of charging a person with one or the other if they end up with the same type of sentence? In other words, the criminal code needs to be looked at again, needs to be redrafted again, needs to be proportional, needs to deal with new situations and our new views, which, for instance, drugs are now a health problem instead of viewing them as a criminal problem. So a new criminal code should be drawn with that in mind. I would say that one good thing about deflection is that, you know, they say the more things change, the more they stay the same. If you go back to time immemorial, which by legal definition is before 1189, which was the beginning of the common law, and certainly before Magna Carta, which was 1215, you will find that clans, essentially in Saxon law and early Norman law, the clans took great responsibility for their members. And the net result is that most things were settled within the clan or between clans, and that even murder was very often not a criminal offense so much as settled by a monetary amount called weergeld. It was the first law creating capital punishment in the English law system for murder was at the end of the 12th century, or the last part of the 12th century. So basically, we're going back now to the community involvement, which I think is a very good idea. And it may have taken a millennia, but we're back perhaps to where we should be. In terms of bail, again, and you might not know this, but the common law of England, which of course is our direct ancestor for the laws of the United States and largely for the Constitution of the United States, if you look at our statute books, you will find that the common law of Illinois includes the law of England from before the 4th year of the reign of James II. So you can go all the way back to Magna Carta and so forth, and all of that has become the common law of Illinois, unless, of course, it's been changed by the legislature. But in terms of bail, the English common law and even Saxon law put a very, very heavy value on freedom. And even in the days when judges rode the circuit and sometimes didn't get back to the same locality in a year or a year and a half in those days riding the circuit, people could apply to get out of jail while they were awaiting their trials. There were at least 4 different writs that could be applied for. And one of them dealt with having sureties. And in those days, a surety wasn't a surety company. It was, again, going back to the clans and all, it was you had people signing on who were assuring the court that they would make sure that this individual appeared back in court when they were required to do so. And all charges, including murder, were bailable in that sense until the first hanging statute when they took murder out, but everything else remained bailable. So basically, and in this country, we've always put a high priority on freedom, obviously. And we have a provision that says that certainly in the Constitution of the United States and in the Constitution of Illinois, that bail shall not be excessive. Now, the real question is, that's always been sort of thought of in terms of just dollar terms, I think. And maybe we should be thinking of it in relative terms as to who is being charged the bail. Because generally, the people who can't make bail are obviously the poorest among us. And we don't believe in jailing people for debt. Yet, when we create the bail, we're creating the debt, and then we're jailing someone because they cannot pay the debt. So I would say that ROR or I bonds are certainly more consistent with our traditions. And also, of all the people that get bond, who are the people that are less likely to flee the jurisdiction? Obviously, the people that don't have the wherewithal to flee and probably don't have the general experience to feel comfortable outside of their neighborhood are the people that are less likely to flee. On top of that, it used to be, of course, that people who knew you, or a bail bondsman, I mean a real separate bail bondsman, would take it upon him with his bail jumpers and skip people and so forth, would take it upon them in a very direct way to make sure that you appeared in court. Today, the extraction of bail is really very abstract. It's almost like the paying of a premium to an insurance fund, and it's somewhere someone might ultimately have to go and get you if you really were intent on fleeing the jurisdiction. But it no longer really stands for what it did historically. And so I think to impose that on people and make them sit in jail because they can't pay their insurance premium is pretty rough, and I don't think consistent with our traditions. So I do think that the project where you are trying to have everyone released on I bond is consistent on the whole. The one exception would be public safety, and those are very rare cases, but where someone poses a direct problem, a terrorist or something with direct safety, obviously you're not going to let them out on an I bond or probably on any bond at all. But the reality is that most other people, the system now, we've come to the full circle again, almost to the point where we should rely on the community and we should rely on telemetry and modern technology and so forth. And ultimately, there's really no need for cash bond in most cases. So those are my observations for what they're worth. Thank you very much.
So I think the tie to bonds here is thoughtfulness, right? Promotion of deflection strategies, any cash bond, offering misdemeanor alternatives to possession of a controlled substance is about being thoughtful about our criminal justice policy. My experience in the justice system as a kid growing up in the city, as an attorney working at 26th Street, as a policy advocate, is that many, if not most, of the policy and practices that we employ in the justice system are not done because they've been tested, means tested, or they are the thing that we know is the best. It's kind of empirically proven to work. Many of the things we do is just because that's what the guy or gal that taught us to do did, right? So thinking strategically and thinking openly about how we reduce the footprint of the justice system, not just to reduce the footprint of the justice system, but to help make communities safer, right? I think one of the biggest barriers to keeping communities safe is that too often we use resources on issues or interventions that we've always done. We've always have done, and not interventions that are the most helpful. So I think these policies are really bringing us on putting us on the right path. So I will open it up for questions. Because I'm closest to the mic and I'm selfish, I will ask the first question. And I wanted to hear is there a response to the equal protection issue when it comes to deflection? The idea that individuals may be treated differently, and that brings some sort of constitutional question.
So there's a lot of lawyers in the room. Here's the thing that you're going to really dislike about deflection. Police chiefs like it because they don't have to involve you as lawyers or attorneys or prosecutors. It's a development of a new field. So right now, remember I said 90% of deflection is no charges? We're not at the point of the 1,100 known sites. How many police departments in the U.S., by the way? No, not 85,000. That'd be, wow. 18,000. We have about 1,100 known departments. We're not at the point where the attorneys are mixing it up yet in deflection. We're at the point where police chiefs are saying, I'm going to do this. I'm going to do it because it's the right thing to do. So that's the first thing, is we're not at that point yet. Appreciate the attorneys in the room trying to jump the gun. Don't jump it too fast. Secondly, let's be real about what goes on the streets, including attorneys. It's called discretion. Every officer out there is using it. All of us love discretion, whether you work at Burger King or you're a prosecutor or whatever. You want to have control over your job. It's going on all the time anyway. Don't pretend it's not, because it's a big, big deal, especially in the justice system. And the third thing I'd say is this, is the idea that we would be using deflection for felonies. We don't see that yet. Again, it's mostly encounters where the law enforcement officer, she is absolutely sure that this person has got a behavioral health issue, and but for taking no action, would really benefit from treatment, housing, and services, so that the next time she sees Jack, she has to arrest me dead or just watching me spiral out of control. So we're not at the point of that yet. It's good kind of legal conversation, but don't stop deflection from that, because the vast majority is just about the next encounter not being as bad or not happening at all. So I didn't dodge the question. I'm just offering that we're not at that point yet of figuring out what that might look like on the street for actual officers who are doing it. We will get there. There will be a case. Something will hit the media. Something will happen, and we'll realize things, but we're not there yet as a field. So best answer I can give right now.
Also, I think it's important for us to remember there's a lot of deflection going on in Winnetka, for example, right? There's a lot of discretion and a lot of different practices being applied to different communities right now. I think we do have a lot of equal protection and fairness issues that are being raised, but I think we should focus on reducing the prosecution rather than worrying about barriers to the deflection.
Yeah, I would co-sign what both of my co-panelists said, and the thing I would add with regard to the issue of drug possession is, you know, currently here in Cook County, and not just under the current progressive state's attorney, but under the prior state's attorney too, there's been a lot of discretion exercised as far as the prosecution of drug offenses, and not only diverting people, but dropping charges altogether. Whereas in southern counties, in rural Illinois, you will see people prosecuted for a felony and imprisoned in the Illinois Department of Corrections for residue of a drug in a bag in their pocket or in their car. So I think the way discretion is exercised in different places does produce inequalities. I don't know that it, you know, rises to the level of a constitutional issue. I think there'd be a lot less concern if the penalties for possessing a small amount of drugs were proportionate to what they should be, as opposed to somebody getting a felony or nothing. But just wanted to make that point, that there's a heck of a lot of inequality and you know, different outcomes depending on what neighborhood you live in, what part of the state you live in, what color your skin is, and a lot of other factors.